Welcome back. The Senate last week amended the Code of Conduct Bureau and Tribunal Act, tinkering with certain sections, especially Section 18, subsection 1 and 2. They transferred the President's regulatory powers over the Bureau and Tribunal to the National Assembly. The Senate also reintroduced a provision which authorizes the CCB to invite anyone found culpable in asset declaration to make necessary correction as against being charged to the tribunal for trial. But there has been argument in some quarters that the Senate, and by extension the National Assembly, cannot make such amendments without first amending the Constitution. Some lawyers react to this issue.
By virtue of the provisions of the Constitution, I think Section 4 thereof, the powers to make laws is vested in the National Assembly. And when I say the National Assembly, it means the Senate and the House of Representatives. Having said that, there is no provision of the law that cannot be amended, including the Constitution itself. I am aware that the CCT is a creation of the Constitution, and if it is a creation of the Constitution, I don't believe it is a law that can be readily amended by just a bill of the National Assembly without following the strict procedures that have been stipulated in the Constitution for amendment of the Constitution, which will include getting, I think, about 2/3 of the House of Assemblies of the states, of all the states of the Federation, to pass a law to amend it. I think that is the position.
You remember in our elementary knowledge of amendments or reading of the bill at the secondary school level, that it has to pass through so many stages. Now, you cannot just so much to get up one day and say, look, we want to amend this. You have to go through the constitutional provision in amending it, because ours is a written and rigid constitution, unlike unitary constitution where 2 or 3 people can just gather together, or military governments where they operate a decree and 2 or 3 of them can just get up and say, look, we are changing this. It is not like that with Code of Conduct Tribunal. And you know, Code of Conduct Tribunal specifically to curb corruption. That is what it is. And anything that has to do that has to affect the rights of citizens, it has to be properly done.
My opinion is that it's akin to changing the goalpost in the middle of the match, in the middle of a football match. That is what I think it is. They have a right to amend any law, as a matter of fact. The National Assembly is established for that purpose, for making laws and amending laws. However, the Code of Conduct Tribunal Act enjoys a special status by virtue of its incorporation in the 1999 Constitution of the Federal Republic of Nigeria. Yes, it is incorporated by reference. It enjoys the kind of status that the Land Use Act enjoys. So I am of the opinion that it cannot be easily amended without, first of all, amending the Constitution itself.
The President has 2 options. The President has the option of assenting to the bill. The President has the option of not assenting to the bill. In the event that the President does not assent to the bill, of course the Senate, the National Assembly, has the right to veto the President, which is a difficult thing to do. But I think that's democracy. I think that's how it's supposed to be played. But I, as a personal view of mine, I think I would rather side with a National Assembly of many members with divergent views, where arguments can be made for and against certain issues and propositions, than for one man who is the President. Which is not to say, I understand the ideas that people have about the fight against corruption, but I think we stand a better chance of having, it is said that it is at the moment where you have difficulties, if you stay true to your values, then you really have those values as your values. So at this difficult moment, if we uphold the values of democracy, uphold the values of having a parliament and having them to do their job, in spite of the fact that we have corruption, then I think that we are well on the way in making headway with democracy, and ultimately, maybe slow, ultimately our country will be better for it.
And just before we go, let's check out some of the top trending stories from the courts.
The former Minister of Aviation, Mr. Femi Fani-Kayode, has regained his freedom after a second stint in detention, first by the Economic and Financial Crimes Commission and then at the Nigerian prisons, Kuje. Speaking to journalists at the court after meeting a 50 million naira bail condition given to him by Justice James Soho, Mr. Fani-Kayode says he is more than ready to face the charges against him. Mr. Kayode, who was surrounded by family members, also says he's used to being detained, having spent more than 3 months combined in detention. Meanwhile, prior to his release, the Federal High Court in Lagos could not proceed with a trial on a 4.9 billion naira fraud charge against the former minister. The counsel to the defense, Mr. Wale Balogun, had informed the presiding judge, Justice Muslim Hassan, that Mr. Fani-Kayode had been remanded in Kuje prison on the order of Justice John Soho, where he was arraigned on November 5, 2016 for a different alleged fraud of 26 million naira by the Economic and Financial Crimes Commission. He also accused the EFCC of engaging in lawlessness as the EFCC operatives rearrested Mr. Fani-Kayode on October the 21st in the premises of the court, despite being granted bail by the Honorable Justice. In response, the EFCC counsel, Mr. Rotimi Oyedepo, affirmed that the rearrest of Mr. Fani-Kayode by the EFCC could not be interpreted as a violation of Justice Hassan's order because he was rearrested in connection with another alleged offense. The presiding justice, Muslim Hassan, stated that it was wrong of the commission not to only rearrest Mr. Fani-Kayode after he had been granted bail by the same court some weeks back. He adjourned the case till December 12, 2016. A federal high court in Abuja has heard how $752,000 was paid into a special account belonging to former Chief of Defense Staff, Air Chief Marshal Alex Bade. According to a release from the EFCC, a prosecution witness, Fatima Daku, told the court that the money she credited into Bade's Visa Gold account was brought to the bank by his ADC and orderly. The former defense chief is being prosecuted by the Economic and Financial Crimes Commission along with his company, Iyalukam Nigeria Limited. He is standing trial on charges of abusing his office by withdrawing 1.4 billion naira from the accounts of the Nigerian Air Force to purchase property in choice areas of Abuja between January and December 2013. Trial judge Justice Okun Abang has adjourned to November the 22nd, 2016 for continuation of hearing. The Court of Appeal has reserved judgment to a date to be announced in the appeal filed by the National Chairman of the Caretaker Committee of the People's Democratic Party, Senator Ahmed Makarafi, and the Secretary, Senator Ben Obi. In the appeal argued by Chief Wole Olanipekun, the appellants are asking the appellate court to set aside the judgment of the Federal High Court in Abuja delivered on June the 29th, 2016 by Justice Okun Abang, affirming Senator Ali Modu Sharif as the authentic factional chairman of the party. He told the tribunal that the trial judge erred in law by concluding that Sharif was the national chairman of the party without giving them hearing before his court. They also told the court that the action of the judge constituted a denial of fair hearing and subsequently led to a miscarriage of justice in the judgment. Objecting to the appeal, counsel to the Sharif faction of the party, Mr. Belu Olisa Nwafo, urged the court to decline jurisdiction on the ground that an appeal had been entered at the Supreme Court to challenge the decision of the Court of Appeal, which granted leave to Makarafi and Obi eligibility to file appeal in the case. Counsel to the respondent, Nwafo, told the panel of justices that since the appeal has been formally entered at the Apex Court and the motion for stay of proceedings also filed, it's automatic for the appeal court to hands up from the matter as a mark of respect to the court hierarchy.
And that's the program for today. Don't forget that you can find these and past episodes of the program on our YouTube page. I'm Shola Shayeli. Thank you for watching.